The purpose of this video is to teach all of you that Democrats could have maximized constitutional authority in order to save us from this. However, they refused because of the quorum. They refused because what? They were thinking as attorneys and not constitutional defenders. In reality, when we look at our founding text, at our North Star of principles and blueprints, it positions that the Constitution is above anything else. Article 6 Supremacy Clause. We know that through Federalist 78 through 83, that positions it even above the legislatures and even above the judiciary. The social contract is supposed to represent the true integrity of the people, the true integrity that was promised from the government to the people. And what Griffin's case, which basically was a case that put into precedent that Amendment 14 Section 3 is not self-executing. Why? Because it would be a discrimination against the Southern rebels who cannot hold office. So it would be problematic if it was self-executing, because that means a lot of people who wouldn't be in office, right? It's stupid, but that's what it was. And then we have Anderson versus Trump, I believe, from the Supreme Court, basically saying that it's not the job of the states, but the job of Congress to actually disqualify Trump from the ballot. Now, Puchu really brings up something that I believe Democrats truly believe, that the non-self-executing declaration cannot be directly enforced in our courts without additional legislation passed by Congress. Now, I want to note that this would be in contradiction with the literal provision of Amendment 14 Section 3. And in reality, that's what the Griffin's case was. It said if we're faithful to this provision based on textualism under Article 6 Supremacy Clause, then it would be unfair to the Southern rebels. So rather, I'm going to have my opinion as a judge, and I'm going to allow for that to guide my decision, which is in violation of, obviously, Federalist 83 position that good behavior is obedience to the Constitution. Unfortunately, through legislation, good behavior of Article 3 means that they're there for life, which is in contradiction with what was originally intended for them to be there unless they mess up. I do agree with the fact that individuals cannot invoke the treaty's provision as a basis for legal claims or defenses in domestic courts. I do believe it is on the branches, specifically either the court or the Congress, in order to satisfy whether or not he's legitimate. And a lot of that is just ambiguity on the provision. However, look at this. Let's take this as true, the fact that you need legislation in order to position that this is self-executing, right? Now, what this provision tells us is that you also would need legislation or a vote in order to push that someone who counts under this is not illegitimate. In fact, it tells us at the end, but Congress may, by a vote of 2/3 of each house, remove such disability. Did they do this? No, they did not. You're gonna say, well, certification, right? They approved it. But that wasn't Congress voting. That was the people who voted, and through the Electoral College, they certified that. That's not the Congress literally voting on whether or not he's legitimate. And that is why if you go through my videos, I position that we have to force them to decide on his legitimacy, whether or not he is legitimate. And obviously, we know through the Jack Smith report that he's not. But what is a constitutional coup? A constitutional coup is leveraging the loopholes and shortcomings and blind spots of the Constitution in order to subvert it. In this reality, the Anderson versus Trump case was positioned as a judicial coup, really. Because what we see here through textualism is that no person shall be a senator, representative in the Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or of any state, who having previously taken an oath as a member of Congress or as an officer of the United States, which is what Trump would count as he was POTUS, or as a member of any state legislature, or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. As a bare minimum, he gave aid and comfort. We know that because of the Jack Smith report. Now we're in this gray zone, right? A gray zone where we don't know the legitimacy of him. So why is he in the White House? Why is he in the White House and we don't know whether he's legitimate or whether he's not? First, they had to make a decision. But because Republicans believe that if there's no decision, then that means he's automatically qualified. This is why we exist and where we exist. But it's because Democrats weren't thinking like constitutional defenders as they should, but they were thinking of attorneys. And American justice is focused on what? Obedience to superior orders and this reality of American law that is a judge. But Federalist 78 through 83 tells us that it is not a judge. It is the Constitution. And the Constitution over here is telling us that they are not legitimate. And for them to be legitimate, there has to be a legislation or a vote by Congress in order to make it so. But we do not have that because it was the people who voted. It was the Electoral College who positioned that, and it was the Congress who certified it but didn't actually vote on it. In this reality, we have a constitutional crisis because we have someone in there who we don't know if they're even supposed to be in there. Specific issue here is quo warranto. Pretty sure I said it wrong, but it's a special form of legal action used to resolve a dispute over whether a specific person has a legal right to hold the public office that he or she occupies. Now, this is to test the person's legal right to hold an office, not to evaluate the person's performance in the office. So, it doesn't matter that he did all these felonies, all of this, whatever, that you don't like him. It's a question of, is he legitimate? Now, Congress has not decided on this, which means that we have someone in there who shouldn't even be qualified to be in there unless they remove it, right? And remember, the fact that the courts decided a certain way does not remove the fact that the Constitution is the law of the land. And this backs it up, Federalist 78 by Alexander Hamilton. Until the people have by some solemn and authoritative act, that is Article 5 of the Constitution, annulled or changed the established form, it is binding upon themselves collectively as well as individually, and no presumption or even knowledge of their sentiments can warrant their representatives in a departure from it prior to such act. Now, while there's a lot of ambiguity in this provision, it also positions that in order for it to be even legitimate, there has to be a vote of 2/3 of each house to remove this disability of being illegitimate, and they have not done that. So what does that mean? We're in this gray zone, yet Democrats have not maximized on constitutional authority. They only maximized on law, but law doesn't have to be in alignment with the Constitution. We know that very well, but the Constitution can't change the rule of law. The rule of law cannot change the Constitution. Only the Constitution can change the Constitution. And it's about time that our courts are realigned to not have such immense power that they can literally disregard the United States Constitution. So what I want you to take from this is that the Democrats did not maximize on constitutional authority. They thought like lawyers, they didn't think like constitutional defenders. And in no reality will what they allowed and what they are allowing every day be justified, because we had supreme law.